going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy hump day. I have got a great video for you guys tonight. I'm actually really excited about this one. Usually there's one or two clips in the hour-long stream that I'm like, it's just meh. Nothing tonight is meh. We've got some fun court from start to finish. I hope you guys enjoyed as much as I did putting it together. All right. Let's see. Before we get into it, giant shout out to everybody that helped me get to 17,000 subscribers. Last night was a lot of fun. Thank you guys so much for that. It was a great stream, and yeah, you guys are awesome. All right, you guys ready to watch some court? I want to watch some court. This is a good one. We've got some SovCits, we got some idiots. Yeah, and that's pretty much it. We're in a bunch of different courtrooms tonight. We're gonna start in I don't know if this court's actually in Madison, Wisconsin. I think it might be, but giant shout out to Miss Orchard Blooms, who gave me the heads up earlier this morning, and she said there's gonna be a SovCit in this court today, and this is the first video. He sounds like he's touching the SovCit script, or at least he's getting close. He doesn't really cross the line in this video. It's still good though. You can see where the SovCit could potentially come out later in his case, but he doesn't really go for it during this hearing. It's still good though. And then I grabbed another one from the same court just about 20 minutes after this guy. All right, I'm rambling. Let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Case. Good luck to all parties.
Next be Gregory Robertson's bail hearing by Zoom.
Call 24 CF 1527, State of Wisconsin versus Gregory Robertson for a bail hearing. Appearances.
ABA Cecilia Martin.
To understand what is the public defender's office appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
I have a copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail could apply to that amount. The defendant has already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that
Heather.
amount back down to $3,000, applying the previous amount. So in essence, allowing the defendant's release after the remaining custody, that release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I have all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on one second. Hold on one second.
Yes, ma'am. Open that for you.
I have no objection, and that's how he wants to proceed. If you're right, just so you know, if you do indicate you do not want a public defender, and that's what I happen to be, so I'm happy to withdraw.
Mr. Robinson, this is solely about bail. What do you think I should set your bail at here today?
First and foremost, ma'am, I think it should be reinstated to what it originally was.
Hold on. Actually, I want to make sure you're capable of representing yourself, sir. It looks like you've done so in the past. How old are you, sir?
I'm 41 years of age, ma'am.
Do you read, write, and understand the English language?
Yes, I do, ma'am.
Have you had any drugs, alcohol, or
legal degree. Yes,
have you had any drugs, alcohol, or medications that interfere with your thinking here today?
No, ma'am.
You fully understand everything I've asked you and everything that's going on, sir?
Yes, ma'am.
All right, what do you think I should do in regards to bail here today?
Well, first off, I want to object to what the prosecutor has said. First and foremost, it's only been one time that I allegedly failed to appear. First and foremost, everything that we filed is being pro se, standing in my own prior persona. And the last thing that I filed, man, was a default judgment. And in this matter, the state has
Sir, we're here solely on bail. So what do you think should set your bail on here today? Please stick to the argument.
Well, ma'am, first and foremost, I think it should be reinstated because it's not right what the state is doing. She just held an open court and just lied and said I missed court multiple times. This is not true. When I was taken into custody, it's because the first time was because the judge that I went in front of, Mario White, jacked my bond up because I wouldn't answer his question. I refused to answer the questions that he wanted me to answer because it's my right. And I chose to remain silent and not answer what he wanted. So he took me into custody to try to make me do a competency hearing against my will. But in this matter, I feel like my bond should be reinstated. I didn't run. I didn't hide. I exercised my right. I filed my paperwork, and time and time again, the state has not responded to any of my filings. Had I been a licensed bar member, all of my filings would have been responded to. But since I am pro se in this matter, they have not awarded me or afforded me.
You're only here on bail here, sir. Only here on bail. Stay focused. What you want me to reinstate? Anything else in regards to bail?
I'm asking for my bond to be reinstated to what it originally was. I just lost my sister.
Thank you, sir.
I just lost my sister December 22nd. I have not had time to go with my family and grieve. I've been in custody since December 12th, and I'm currently in custody right now. So I'm asking for you to do the right thing and allow my bond to be reinstated. I did not bail jump. I didn't catch any new charges, ma'am. In this matter, no new charges. I did not catch any new charges. And I'd appreciate it if the state didn't lie and say that I missed court multiple times because this is not true. And then you're standing in court, in open court, lying under oath. You're a public servant. I'm a
All right, sir. Focus. You've made your point, and I do see that you only missed court one time on this case, okay? So please continue. Anything else you want the court to consider in setting your bail?
I want the court to consider that I am pro se. I don't have the college education that she has. I don't have the ability to sit up and lie and try to tarnish her character in open court. I just pray that this court and that you, man, have leniency and respect that I'm here trying to do the right thing.
All right. Thank you, sir. Cash bail was set at $3,000.
Yeah, thank you, sir. Please let the record reflect that he does not have a college education like the prosecutor does. So PR bond, and she lied on me. So let me out. That's pretty much his defense. No, again, thank you so much, Miss Orchard Blooms, for sending me this. This is awesome. Thank you.
$1,000. It was posted. That was not enough to make you appear at court. So I have no choice but to increase cash bail. They had to extradite you in regards for today's hearing. You wouldn't voluntarily appear when you were supposed to appear. I will therefore set cash bail in the amount of $25,000, and I will reinstate all non-monetary conditions. Looks like time limits have not been waived.
Commissioner, that's consistent with my review of the file. Because of the timing of this hearing and the time limits not being waived, it looks like this will be set next week with Judge White again. He is duty judge next week.
Preliminary hearing shall be scheduled accordingly next week, so it is timely. We are adjourning your case, Mr. Robinson. Good luck to you, sir.
Next to me, Paris Tompkins.
Okay, bye. I hope I get that guy's next appearance. I really do. But what Miss Orchid Blooms was saying is he is married to a script loving sovereign citizen, and he's kind of testing the waters. He hasn't gone full SovCit yet. I'm hoping by his next hearing he will. So I'm gonna make sure that I follow that as well as I can and get you the next one. All right, we're staying in the same court. This is the exact same court. This happened about 20 minutes later. Another good one. Not a SovCit, but a little bit of attitude. I don't know what's going on in Madison.
Roll call 25 CM 57, State of Wisconsin versus Samuel Smith, appearances.
ADA Cecilia DeMarco for the state.
Attorney Shannon Woodard would like to finish off screen on behalf of Mr. Smith, who does appear by video from the Dane County Jail. Will acknowledge, and he's eligible for a public defender. And advise the court that if you have a copy of the complaint, we agree to that complaint that has 2 counts that are misdemeanor matters. While finding the problem caused by the court, we stand you task court general fees are not guilty.
I have reviewed the criminal complaints. I do make a probable cause finding. I will enter a not guilty plea on Mr. Smith's behalf. State's position on bail.
The state is asking that the court impose cash bail in the amount of $200 in this matter, if the conditions that the defendant be banned from the UW Hospital East location, except in the event of a legitimate medical emergency. The basis for this recommendation is that the defendant was released on a signature bond in Dane County case number 24 CM 2797. He then had cash bail imposed in 24 CM 2577. Subsequent to that, the state believes that some cash bail is necessary due to all of these incidents involving some level of repeated resistant behavior exhibited towards law enforcement when attempting to frankly assist him.
Attorney Woodard.
Your Honor, this is a new year. We're asking that Mr. Smith be given not a second chance, would like to be a third chance. But he is eligible for a public defender, which means that his wherewithal is right. Mr. Smith, can you post any cash bail, sir?
Hey, excuse me, I'm gonna speak. I've been sleeping outside. The police told me if he see me, it was 10 degrees. I've been sleeping outside this whole month.
Sir, hold on. You don't want to talk about the crime at all. Everything
I
you're
didn't do no crime.
right, but you don't want to talk about the fact. Hold on. You don't want to talk about the facts of the case. There's somebody who was taking out everything you say, and you don't want anything to be used against you. Okay?
I want everything being used against me.
So
Listen,
I
want you to hear me. It was 10
we're not
degrees.
talking.
The police said that.
We're not talking about the facts of the case.
Okay.
We're setting bail here today. That's what we're talking about. Okay? The criminal complaint details thing.
Okay,
Don't
let's talk
want to talk about the
bail.
case.
I did not bail jump. I've been sleeping outside every time the police see me.
Sir, we're gonna mute you because we're not talking about the case here today. We're talking about bail. Attorney Woodard, any arguments in regards to bail?
I think a signature bond is suitable, Your Honor, in light of the fact that he found himself in a situation minding his own business, at least according to Mr. Smith, and I concur with that recommendation of a signature bond that he is also requesting.
Yeah, he's still yelling. We can't hear him though. They muted him. I wish we could.
I believe that I read the probable cause statement in this case, and Mr. Smith was brought in regards by the police for potential exposure. He then becomes belligerent and refuses to leave for the criminal complaints. Given those surrounding facts and circumstances, I am going to give Mr. Smith a signature bond. I'm going to order that he is banned from the UW Hospital East except for all legitimate emergency purposes. We are adjourned in Mr. Smith's case.
Thank you.
Next will be Aaron Finn.
All right. We're gonna move on from Madison. Like I said at the beginning of the stream, I've got a bunch of random clips tonight. They're all good though. I don't remember the order. I know I have a Judge Simpson clip, a DeSanto clip, a Judge Meineke clip. We finished with Judge Meineke. I know that, and Judge Simpson's kind of in the middle. Don't know the order of the rest. So let's just go. Let's have some fun. Oh, wait. I got to shout out Carla. Carla, thank you so much for the super chat. I appreciate it. And thank you. I assume you mean the video I put out this morning. We it wasn't a stream, it was just a video. But thank you, I do appreciate it, and thank you for the super chat. All right, now let's go.
All right. The court is going to talk to Shannon Phillips. She's still here. Miss Shannon Phillips?
Hi.
Hi, ma'am, we've been trying to put you into a breakout room with the attorney and you have been refusing to go. Is that correct?
No, I haven't gotten a notification. No, I haven't gotten a notification. I haven't seen
you don't get a
I've been
notification.
literally sitting here watching.
You don't get a notification, you just get put into the room. And so has she been coming back out? Okay, we'll send you another notification to go while I'm sitting here so you can.
Okay, so what's happening?
You're gonna go into the breakout room to talk to your attorney, ma'am. All right.
All right, MB caught it. I was trying to sneak a SovCit by you. This is a sovereign citizen that I was really excited about today. She has been confrontational with Magistrate Braley. Her last appearance with Judge Washington, very confrontational. Yeah, I've got some bad news. This is a really quick hearing. You're about to see why. I'm not going to spoil it. For those of you that haven't seen this yet, I'm not going to spoil it. But before I do hit that play button, Biggin, thank you so much for the raid, Biggin. I do appreciate it, my friend. Welcome to all the Biggin Raiders. Thank you so much for hanging out with us. Please hit that like button on the way in. I would appreciate it. And there's really nothing to catch you up on yet. This clip just started. Nothing really happened. This is a SovCit, and it's a quick one. But we're just jumping around to random courts tonight, so you have not missed anything. Again, thank you, Biggin. Let's go.
The court will call the matter of Shannon Phillips, 24W001656.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Shannon Phillips. Shannon, could you please state your name?
On the record, for the record, and let the record reflect, Shannon Sherelle Phillips is my organization. But I, Shannon Phillips, I am the secure party and I have a secure interest in that organization. I do not consent. I do not give written or express consent for you to move or administer my organization.
All right. If Shannon Phillips
Shannon
is not
Sherelle
here.
Phillips, which you guys have on the record, is my organization. I am Shannon Phillips, the natural one.
Judge, could Ms. Muller and I approach briefly?
Of course.
Judge Washington was so happy that her internet cut out. Yeah, she was halfway into her spiel and her internet just dropped, and Judge Washington's like, "All right, moving on, let's go."
All right, we're back on the record in the Shannon Phillips matter.
Yep. Sorry, Judge, I left a little early.
No worries at all. It too. Sorry.
So, Your Honor, after reviewing this case, I'm going to move to dismiss this ticket.
This matter is now dismissed, ma'am. You're upset.
Yeah, that's it. That's it. That is her, I think, fourth time that I've seen her in court. I've followed her since her arraignment, and that's it. It was just dismissed. And we don't even find out why. They don't put that on the record. So now we're gonna have BSBT in the comments saying that she won. She won. She beat the system. She won. Yeah, we don't know what happened. They just dismissed it. Anyways, let's move on. I'm not gonna hark on that too much because I was very disappointed. But let's go.
Your
What we got next?
Second would be Mr. Darin Carver, who,
All right, Darin Carver, bottom right. I want to just point to just look at his name. Look at his name. This is what he decided to come to court with. I had to read this a couple times. So I was like, oh, maybe that's not English. Oh, no, it's English. He just can't spell. All right, this is funny.
we're seeing there on Zoom. Mr. Carver, if you could just be still so we don't get too much motion on the calendar. Your Honor, Mr. Carver has 4 cases, numbers 2 through 6 on the 9/30 calendar. Mr. Carver is very close to being licensed again. So we're asking the court to set these over for about 30 days, find this as an excluded period, and we will be resolving these short of going to any jury trial.
I believe there's one on for arraignment. Let's see.
Oh, that is correct, Your Honor. The case number 5 on the calendar is on for arraignment. At this time, we will waive formal reading of the complaint and advisement of rights. We'll enter a plea of not guilty on the case ending in 2081. And if we could have all 4 cases tracked together and find this an excluded period, I'd appreciate it if we could get a court date around the end of February or early March.
On the case, they're pre-trial in the arraignment. On the case ending in 081, plea of not guilty will be entered, get conditions of continued release or don't have any criminal law violations. Don't drive without license or insurance, and make all your court dates.
And Your Honor, if the state may, those conditions state was going to request, but also, I mean, this is another, I recognize they're D3s, but this is another law violation while he's on release conditions on other D3s. The state was going to ask for bail.
Ms. Rowe?
Your Honor, I would ask the court to allow Mr. Carver to stay out of custody. He understands that he cannot continue to pick up new driving charges while he's dealing with driving charges. And he is willing to abide by that condition. And as I stated, I believe he's gotten his tickets.
You know, Ms. Rowe, I was going to wait till the end to comment on this, but I'll be blunt with you. I'll be blunt with Mr. Carver. I'm not sure someone who comes to court on criminal charges, who has his name as Mr. Misbehaving, fully understands that he's not supposed to be doing that. He also has a new felony charge out of Pierce County. He's sitting on court smoking. You're in court right now, and you're smoking a cigarette like you're hanging out in a bar someplace.
I apologize, Your Honor. I had no idea that I was on.
Yeah, I'm not. So I appreciate what you're saying. I don't have the confidence that you do, apparently do, that he does appreciate everything that's going on here. Or otherwise, he'd have a little bit more self-awareness about what he puts on his computer frame when he's coming to court on criminal charges, which are minor. They're not major. And you know, given his experience in court, I would think that he would have enough sense not to be smoking in court, basically. I mean, you are in court, and I know it's a little bit less formal now that we're on Zoom and all of that, but you're in court, and you should act like it. You should know how to act like it.
I'm very sorry, Your Honor, and I paid my ticket for $350, and I spoke with my child support agent. It's going to allow to release the whole license.
Yeah.
I don't think he was smoking during this clip that I got, that I grabbed from the docket, but he was smoking a chimney leading up to his case. He was just walking around nonstop. I think he smoked 3 or 4 cigarettes in the half hour before his case was called.
You have another. recent DWLS in the third. That doesn't look like that's been paid yet. That's $849 for no insurance, improper lane usage, and apparently expired vehicle registration. So you've got another ticket you need to take care of also. Do you understand that?
That I did not understand, Your Honor.
Okay. So, and the best thing you could do for yourself right now is not say anything.
Okay.
Your Honor, I understand the court's concerns. And I do believe that these cases will resolve, and we are asking the court not to require Mr. Carver to report for custody. I believe that Mr. Carver has taken your admonishment and will not appear in this form or fashion going forward.
So confirmations on these is set on February 7th. That date's going to remain on the new charge. The pretrial will be on February 7th. Was it too late to attach these infractions to track with it?
No, it's fine.
Okay. The new infractions will track with it. You know, just from another thing that I've never quite been able to understand. I mean, you know, it appears that your issues are financial. And, you know, you'd save yourself a lot of money if you would think about how much money you put into cigarettes each month. And you don't need to respond to that, but just going to leave that as it is. But given the nature of the charge, and you're here today, I'm not going to make you post bail, but you need to, you know, get a clue here. You understand?
Yes, Your Honor.
We'll see you back here on February 7th.
Thank you, Your Honor.
You may go.
Okay, bye. All right, yeah, that's it. I don't know what's next. Hold on, let's see. Oh, this one is good. Who did I see? I saw someone already put this out. It's still good. I had to add it. This is, yeah, Judge Santo, 27th District Court, Michigan. Let's go.
In the matter of the City of Wyandotte versus Leslie Kinney, 241684, 183393, 173878.
Your Honor, good morning. Richard T. Serrano, P. 3828 attorney on behalf and with my client Presley housed in the Wayne County Jail. Please state your name, ma'am.
Please unmute. Leslie Kinney, please unmute.
Yeah.
Okay.
What do you say? That's been call Kenny.
Okay. So as to the most recent case from November, counsel, of possession of drug paraphernalia. What are we doing?
Your Honor, my client is pleading guilty as charged to that count, and his prosecutor's recommended time served. I explained to my client that's only a recommendation. That sentencing is entirely in the discretion of the Supreme Court. And the other matters are subject for review, Your Honor. I don't know what it's alleged that shows some past monies. She's pleading guilty to everything.
All right, Ms. Kinney, please raise your right hand. Do you solemnly swear affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yeah, it's the truth.
And you heard the plea that your attorney placed on the record, correct?
I can't hear you say.
You heard the plea that your attorney placed on the record, is that correct?
Yes.
As to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
And you got over your advice of rights with your attorney, is that correct?
Yes.
And you understand all of those rights?
Mm-hmm. Yes or no, ma'am?
What'd you say?
You understand all of those rights, is that correct?
Yeah.
And you also understand the possible penalty as a result of your plea, whether in this court or any other court or administrative agency.
Mm-hmm.
Yeah, I need verbal answers, not non-verbal answers or sounds. So is it yes or no?
Yeah, I'm saying yeah.
Okay. And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
You said, okay, agency?
You understand the possible penalty, correct? And knowing all that, do you continue with your plea?
Yeah. Huh?
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
I'm just gonna plead guilty. He said so time served is all he told me. So I'm gonna plead guilty with time served. I'll say time because I don't have no money. But I'll say the time though.
Yeah. I just need to make sure that nobody's promising you anything, threatening you, or coercing you for you to enter into a plea.
Yeah. You said enter into a plea? I'll plead guilty for the case because I don't have no cash. It's all I'm saying. I don't have no money.
I know.
Yeah, boy, I'm not paying shit. So I don't know how y'all gonna get it. Like I'm not paying no money.
Hang on,
Okay, listen. You're in court, so you don't. There's no cursing in court. Is that
I
clear?
don't have no money. I'm just saying I don't have no cash to pay for the duty or whatever. I don't have no money.
Excuse me. Yeah, I just need to know for the record. Has anybody threatened you for you to enter into a plea today?
Since the fuck I've been here, it's been a threat. It ain't been nothing but a threat. Y'all don't know what the fuck y'all can't get the case right. Every time I come in, none of this is making any sense.
I can't understand her.
So, I mean, what you trying to do? Here you go, thank you.
Your Honor, that's what we have.
No, Deputy, we were not done with her. She just walked out.
Nope, hold on. Whoa, we're not done yet.
Your Honor, I just want to say for the record. Most of the time when I'm interviewing her.
Your Honor, she's refusing to come back in.
That's great. Okay, that's good. Continue with the plea, so I guess we'll have to set another date.
Hello? Can I say something? I'm her brother.
Well, hold on. No, sir. No, you may not say anything. You're here observing. Would you if you like, sir, if you like, I can put you in a breakout room with her attorney and you can have a conversation with her attorney, okay?
Yeah,
So
that'd be great. Thank you very much.
You are very welcome.
Your Honor, I don't know why I have to speak to her brother. It's got nothing to do with this case.
I'm presuming he may talk. He may have
He's
something.
incompetent to talk.
Mr. Kinney, please stop talking right now. You're not identified for the record, so just one moment. Counsel, he's been on Zoom all morning. This is his sister. Perhaps he has some insight that he can give you regarding his sister. So if you could please log back in.
Okay.
So we can put the two of you in a breakout room. We're going to adjourn this matter for Ms. Kinney to January 15th. Okay.
All right, Your Honor, I'll be back as soon as I can.
Okay, I'm sorry, Mr. Serrano, are you here next week?
Yeah, MB, I absolutely agree. If I was, I don't know, if I was the brother who's obviously concerned about his sister, I would be doing anything I can to get a different attorney because that was ridiculous. I don't know why I have to talk to him. He has nothing to do with the case. Talk to him. Why is it gonna hurt? I know you're busy. So is the brother. He's probably busy. He probably took a day off work to look out after his sister. I found that very distasteful of that attorney to do that. I'm sorry. I'm glad someone else said it though. So MB, thank you for backing me on that. I probably wasn't going to say anything, but I'm glad you did. So I was able to speak up. All right. Before we go any further, Toby, thank you so much for the super sticker. I do appreciate it. Toby, you are awesome. Thank you. All right. Let's see. What do we got next? Moving on.
Courthouse game.
All right. This is a little palate cleanser. Yeah, Judge Simpson. We all love Judge Simpson. This is more funny than anything else, and I want to thank Lauren, the pet lover, for sending this my way. She let me know the time of the docket that this happened, and she did not disappoint. She was right. She was right on with this one. So let's go.
Case of the People versus James Lawson.
That's a lot of good people.
So on behalf of
Really?
Your name, sir?
James Craig Lawson, for the record, Your Honor.
All right. You are before the court on the charge of improper registration or plate on a vehicle. Alleged to have occurred on April 3rd, 2022 on Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan.
I'm sorry, I need those headphones so I can hear.
Oh, okay. No, that's
I
okay. No,
apologize.
don't. That's okay, Mr. Lawson. Don't apologize.
Okay.
You got it now?
Yeah, I can hear you.
Okay.
All right.
You didn't have to apologize. I should have remembered, but
That's okay.
All right. Okay, so you're before the court on the charge of improper plate or registration on a motor vehicle alleged to have occurred on April 3rd of 2022, Ellsworth Road, Pittsfield Township, Washtenaw County, State of Michigan.
Yes, sir, I'm aware of that charge. If you'd like some feedback on that, I'd love to give you some.
No, I right now I don't need any background on that. Let me just ask you this. That's a misdemeanor. Well, let me tell you, that's a misdemeanor punishable by up to 90 days and a $100 fine plus court costs. You understand that?
Yes, I do.
All right. First question I have for you is, do you want to be represented by an attorney on this?
I don't think I need to be represented.
Well, hold on a second. You've got an attorney, you've got the PD on other cases, don't you?
Yes, I'm in circuit court now. I've been in since August 2nd of 2024, and I'm supposed to be released on February 5th when I return back to circuit court with time served, no court costs, no fines, no probation. Supposed to be released on the charges that I'm serving for now on a plea
Okay.
deal.
Gotcha. So let's do this. I'm going to have you stand mute to these charges, not say anything about it at this time, and I'm going to enter a not guilty plea. Okay?
Okay.
And then you said you go back to circuit court on the 5th.
Yes, sir.
When's my date? So here's what I'm going to do, sir. I'm going to adjourn this case out to February 19th, 2025 at 9 a.m. Okay.
Okay.
And then I'm just going to grant a personal recognizance $5,000 bond on this case. So this one's not going to hold you. You're also not getting credit, but I'm not going to worry about that at this point. And then I'm going to give you a PR on this case. Okay.
Okay.
After you get finished taking care of all of the other stuff, come back here. We'll figure this one out. All right.
Okay.
I'm also this is going to be a public defender case, so they can track it for you with the other thing.
Okay.
Follow me. So any one of you want to stand up next to your new client? No, I'll wait.
Under Natalie Pegwich, on behalf of Mr. Lawson, I believe he already has his bond and future date.
Yes, he does. All right. And so this public defender case. And so that way they can track what's happening there with this one, and we'll figure it out.
Yeah, as far as I know, on February 5th, before Your Honor Colin at circuit court, I'm supposed to go for sentencing. And with the time that I have in from August 2nd till then, all my time is served with 142 days credit. And I thought today you were bringing me back in for that $11 court cost that I owe.
You owe me $11?
Yes, sir.
You do?
Last time
Why was I so nice to you then? Does he owe me $11?
Yeah, I owe you $11 from 2010 on a retail.
What?
Yes, sir.
I knew I was missing some money.
I was going to ask you if you'd loan it to me, I'd pay it off and we could close the case.
Whoa, you want me to loan money to pay out? But What kind of case is it on, Mr. Lawson?
It's from 2010, a retail fraud. It's a misdemeanor. It's a Target store on Carpenter Road for 2 CD players and a pair of Sony studio headphones.
Wow, you got a great. It's 11 in restitution.
Well, the restitution was $150, but the court cost was $11.
Oh, okay. So you got to get that 11 paid.
Yeah.
I can't waive that.
That's fine.
And then what I was going to do, get the 11 paid. That's actually restitution to the store, and then I was going to waive all the rest of your stuff.
Well, that sounds great. If you asked me the last time I was here, what happened to the $150 you were supposed to send me when I got out October 19th of 2024, and I said I had sent the money, and I sent the money order to the wrong court.
Yes.
So, and then I thought maybe you was bringing me back for the $11 today because I'm still here, and that's why I brought that up.
Got it. Okay, so here's a. You said I put that in the file. That's what I do.
It's notated.
Okay, so in the file, that $11 I can't waive.
Okay.
It's restitution to the store.
Yes.
So you get that $11 paid, and what I've indicated, the record indicates in there, you get that $11 paid. The rest of it's going to go. So fines and costs on there.
Thank
Okay, fair enough.
Thank you.
All right. So I want my $11. No, I'm kidding. All right. All right, Mr. Lawson.
Thank you, sir.
You take care of yourself.
You too, sir. Thank you.
All right, all right. Like I said, a little bit of a palate cleanser. I think we have one more before the grand finale, which is Judge Meineke. Let's see. Hold on. I think there's one more. Nope. This is the end. This one's a little bit longer. I think this one's about 20, 25 minutes long. So we're not cutting it short tonight. Do not worry. This is a longer clip. This is weird. This is I think this guy's a potential squatter. He has some SovCit vibes going on with, you know what? I'm just gonna let you guys figure it out. This is weird. I'm gonna tell you right now, this is a weird one. All right, let's go.
Okay, Mr. Wasbury, Mr. Robertson is here.
Okay, Judge.
Mr. Calling SNH Real Estate LLC versus All Occupants 2402640. Mr. Wasbury is here. Your appearance is noted for the record, sir. It's come to my attention that on this case, David Robertson has filed an answer. Mr. Robertson, are you there?
Yes, Judge. Thank you all for your patience of what have you. I'm having a little problem in clearing the message on the screen so we can see each other there. I mean, I'm seeing portions of you, but I want you to clearly be able to see me. But I'm there, sir.
Okay, I can see you fine, sir. There may come a point in time where I have to stop your video because sometimes with the internet connection, sending video and audio is a drain and it makes it choppy.
Yes, sir. I understand you.
So I might have to shut off your video. I can still hear you. I know it's you, Mr. Robertson, but I might have to shut down your video just to make sure you can hear me and I can hear you.
Sounds good, Your Honor.
Okay. All right. So we now have counsel. We have Mr. Robertson here.
Okay.
Would you like to speak to Mr. Robertson or just proceed forward on the record?
I think I'd like to proceed forward on the record, Your Honor.
All right. Mr. Robertson, can you still hear me okay?
Yes, Your Honor. And if I may add in, Your Honor, I just didn't want to be rude. At any moment during these particular proceedings, the actual owner will be walking in the door. He's 85 years of age, and I'm asking you out of mercy, because he's supposed to physically be sitting on the right-hand side of me, and unfortunately, he's not. So I've instructed the fine staff here at the library in the event he walks through the door and inquire where these hearings are, that will not offend you or the plaintiff there. I just want to make aware of it.
All right, well, who is it that you're expecting to see, and who is it that you believe is the actual owner, if not SNH Real Estate?
The gentleman's name is Mr. Harry Ray Jarvis, and based on, not my opinion, respectfully, Your Honor, but according to Oakland County Clerk's Office, Registered Deed Office, in addition to licensing and regulation affairs, which also is commonly known as LARA. This is their documentation as well. And also, Your Honor, the local municipalities, such as, I forget her name, but she was very kind. I believe she held the post as the director of the Royal Oak Tax Assessment Office or what have you. And another issue had ensued from there after her research, Your Honor. But at any rate there, these are the various reasons that I stand strongly on my belief, simply because I have all necessary documentation to confer that, in addition to submitting those documents to your office, along with the office of the attorney representing Mr. Brooks, Your Honor.
Okay, hang on. All right, Mr. Wasfree, any comments on this?
Yes, Judge, he did attach to his answer a memorandum of land contract, wherein Chad Hooks, as a member of SNH, is the contract holder. So this is dated March 4, 2024. If I could voir dire Mr. Hooks and ask him when he came into possession and when Mr. Robertson came into possession, I think that would clarify what's happening here.
I mean, that
this is a, I guess the tenant is it. This is an interesting case. The guy who's speaking, they had to turn his camera off. He's at his local library, and he didn't have very good service, so his camera's off. But he was on camera for a minute at the start of the hearing.
What you're describing sounds like a hearing, a trial.
Yes, Judge. And keep in mind, he broke in, and that's why we're trying to get our judgment today. Yes, Judge.
Trying to get through Mr. Robertson's answer.
All right, it took him about 5 minutes to read that. I didn't want the dead time. You know, kudos to me for finally remembering to edit something out, though. Yay! I'm getting better at this, guys.
All right, so here's what I don't understand, Mr. Robertson.
Yes, sir.
It seems as if you acknowledge that there is at least a memorandum of a land contract that existed between the plaintiff here and Mr. Javins to take, looks like to take possession of or ownership of the property. Mr. Wasfree, it looks like in January of last year, 2024.
Yes.
And so Mr. Robertson, here's my question to you.
Yes.
What is it? It seems as if some of your arguments are that Mr. Javins is still the owner of the property. What this document, this land contract suggests that he's not the owner, that he's contracted with the plaintiff here to sell the property.
May I speak now?
Yeah, go ahead.
Thank you for your patience. Initially, there was an agreement, and this is according to what Mr. Javis has shared with me, has told me, Your Honor, not my personal opinion. First and foremost, if I may, Your Honor, respectfully, simply, respond to the plaintiff's term that I broke in. Breaking in is an unlawful entry. Your Honor, I have before me and also in the packet that I have submitted to you and the plaintiff a residential lease agreement. And when you read that agreement, Your Honor, respectively, down where item 3 covering the term of the standard lease, it clearly tells you I originally moved in there, Your Honor, of August 28th of 2023. I'm there a whole year before the plaintiff even surfaced. This is what the lease says. 2023, August of the 28th. And if I may humbly say, Your Honor, respectfully, with all due respect, sir, the Mr. Brooks, if I'm not mispronouncing his name, never, ever showed me anything in terms of a memorandum, land contract, or, sir, respectfully saying, or the actual land contract that he boasts that he has. And finally, respectfully, Your Honor, according to not me, David Robertson, nor Mr. Harry R. Javins, but according to statute, Michigan Code of Law, section 565.361, which covers land contracts in its detail, and it was acted 237 of 1879. It simply says this: payment and performance of contract obligations, and it's dealing with the right way and according to the law of conveying land. It clearly says this, Your Honor, a land contract is a contract for sale of land, or any interest in that land shall be executed by the vendor, that's the buyer, named in the contract and acknowledged before any judge or any notary public within the state. And the officer taking acknowledgement shall endorse a certificate of acknowledgement and date the making of this contract. But more so, this
Hold
is
on,
where...
Mr. Robertson, hold on.
All right, I was waiting for him to finish. Wixom, happy birthday, my friend. Happy birthday. Thank you for spending some of your day with us. That is awesome. All right, before you go on, though, Cheshire Cat, thank you so much for the super chat. Yeah, those fire editing skills at work again. I know, right? I know. It's only taken me 17,000 subscribers to get better at this. Sparkle Boots, you too. You jumped on the bandwagon. Thank you so much, Sparkle Boots. I appreciate you. All right, let's keep going. We still got plenty of this. Don't worry, guys.
Yes, sir.
Hold on. All right, bear with me 1 second. I want to check one thing.
Yes, sir. This is statute. This is Michigan Code of Law. Yes, sir.
Hold on, Mr. Roberts.
Yes, sir.
Okay, so Mr. Wasbury, this is a pretrial. He has appeared. I don't know at a pretrial, although there are a number of concerns that I see with the documents that Mr. Robertson has presented, including this lease that is unsigned, that I don't know that I can, I don't know of anything under the court rules that allows me to just move to a finding of fact at a pretrial. He's here today. I don't know how I can act sort of just sua sponte and make a ruling. In addition, he's filed a jury demand and paid the jury fee. And so the court is, certainly in a challenged position here, Mr. Wassery, because you and your client have taken a position, he's taken another position. If he hadn't filed a jury demand, we could just set this for a trial, and I can determine whether or not there are even triable issues. All right, but he's filed a jury trial, and I don't have that ability to take even testimony today, because we're not here for a trial. So I guess I'm trying to figure out how to get this moving as quickly as possible, because if, as you've alleged, by way of your client, if what you've said is true, I would want this to move as quickly as possible as well. All right, so that I'm not diminishing the need for haste, but I'm also looking at the court rules, and I don't know that I can jump from A to B with Mr. Robertson being here. So it can't, obviously there's no default that would be issued. He's here. Okay. And since it's a pretrial and not a hearing, and we're not all in person, and I'm not swearing anybody in, and I'm not taking testimony, because that's not what today's point is. I guess, I'm trying to figure out timing wise what next steps are. What would you propose, Mr. Wassery?
All right, real quick. Happy birthday, Cynthia. And yeah, I saw that. I saw that it was Elvis's 98th birthday. Not 98. I don't know why I said 98. 90th. 90th. Why did I say 98? I even saw 90 in my head and it still said 98. All right, anyways. What was that? What else was there? Oh, Sparkle Poops. Sparkle Poops! Thank you so much for the super chat. I nominate Serena as campaign manager for new sub milestone. You edited. Yeah, she is hereby nominated. Thank you, Sparkle. I appreciate it. And PCC, Paracourt Channel, thank you so much for being a member for 5 months. That is awesome. Thank you so much, PCC. I do appreciate it. All right, let's keep going.
I would ask this be set for another pretrial 1 week out. I would ask for an order of escrow. This is a very nice property in Royal Oak. I would think Mr. Hooks could easily get $1,800 a month for this apartment. I'm asking for an escrow order under the court rules. If at $1,800.
To be fair, Mr. Hooks did acknowledge on the record that there's not even a bathroom in the location right now.
That's
exactly.
That's not our fault, Judge.
No, I know. I'm trying to figure. I'm not saying that, counsel.
Nor a think, Judge. All that does is confirm more so what I'm saying. Now,
no, Mr. Robertson. This court. Mr. Robertson.
Yes, sir.
This court
Yes,
is not making any findings of fact right now. All right.
Yes,
I'm just trying to come up with an appropriate escrow order, because I agree with Mr. Wassery. If you are remaining in that location and there's a dispute over this, there needs to be monies put into escrow, so that ultimately, when this case is decided one way or the other, if you have the right to that property, then pursuant to some lease, then any monies that are put in escrow would be put towards the rent of that property. If it's determined that you are not in proper possession, then Mr. Hooks, for the time that he was out possession of his of property that he has the right to, then he would be compensated by way of the escrow. That's a fair request, Mr. Wassery, to consider an escrow order. All right, so if we come back here in a week, though, I mean, I'm still going to have to set this for a jury trial. He's made a jury demand unless there is some type of motion. But under the court rules, a motion of this dispositive nature is going to require some time period for notice for Mr. Robertson.
Yes, Judge. If the court orders escrow, there's certain provisions in the court rule that if he doesn't pay the escrow, then we can have our bench trial within 14 days. And the standard escrow is that he needs to make a pro rata payment within 7 days of today. If the rent were $1,800, it'd be $1,335.48. And then on February 1, the full amount would be due for the month of February.
Excuse me, Your Honor, just to
Mr. Robertson,
remind.
Mr. Robertson, just so I know, under the terms of your lease, that you say that you have with Mr. Javins, let me pull that document up again. How much were you to be paying a month?
To Mr. Jabin, sir, is that the question?
Yes.
Okay, beautiful question, and it demands a beautiful answer. Mr. Javins has charged me $200 a month. Why such a low amount? Because during the time, and also now, Your Honor, that house is completely under construction. And also, it's not only have no bathroom, it has no sink. That's why Mr. Javins has found it appropriate to charge me such a low rate. And furthermore, please, Your Honor, according to the law, to assist, if I may, in making a determination according to the law that's in effect right now as we speak, section 565.351, subsection clearly points out, until the plaintiff has fully paid and performed the obligations under that contract, which is a precondition for the sale and conveyance of land. The vendor, once again, respectfully, is the seller, Mr. Javins, named in the contract, then shall he make conveyance of the land to the vendee, Mr. Brooks, by way of deed of conveyance as specified in land contract. And he hasn't paid a thing off. That's a violation of the law.
Hang on, Mr.
And
Robertson.
he
Mr.
has
Robertson,
to.
hold on, Mr. Robertson, hold on.
Yes,
Hold on.
sir.
We're getting into what I would assume would be the actual arguments at a trial. All I'm trying to
So
figure
how
out right
can
now,
he has the
Mr.
right?
Robertson, Mr. Robertson, all I'm trying to figure out right now is an appropriate escrow order. So when's the last time you made a payment to Mr. Javins regarding your tenancy? When's the last time you paid him?
Yes, sir. The 3rd of this month. Each month, I'm scheduled to pay January 3rd, 2025, in accordance to the residential lease.
In what form is these are yes or no questions, Mr. Robertson?
Yes, sir.
And this one just requires a simple answer. In what form was this payment? How did you pay Mr. Javins?
Cash, C-A-S-H.
You paid Mr. Javins $200 in cash on January 3rd, 2025?
Correct, sir. In accordance to the lease agreement. Now, I'm just humbly asking, how on earth could the plaintiff ask for such uncommon amount? First and foremost, he doesn't own it. And secondly, the lease that I'm currently in, says another.
The lease that you provided to me that is Mr. Robertson, that is unsigned.
Okay, I'll give you that. An 85-year-old man, but he will be here. He will be here, and he'll tell you the same thing. And if need be, Your Honor, with all due respect, he will sign it. The issue is this gentleman here and his attorney, according to the law, not my opinion.
Mr. Robertson, I
understand. My apology. My apology, sir. My apology. I just want to make sure you have a clear view of the facts, because it's representing me and an attorney. I'm not.
Mr. Robertson, I've given you wide room, and I've given you plenty of time to speak on this.
Sir.
All right. So
Yes,
now it's time for you to stop speaking and allow the court to make a decision and a ruling. All right.
Yes, sir.
Your Honor?
Yes, sir.
Yes, sir, Mr. Wasbury.
If it has no bathroom, the city should never allow him to, it doesn't pass any codes if it has no bathroom.
There are probably a million questions that I have related to this. So the challenge that I'm running into is there's Mr. Rossfrey, there are so many red flags with what Mr. Robertson is saying, especially when it comes to being able to lease a property that is not fit for somebody to live in. It would not be, based on what I can gather, it's not suitable for occupancy. And so that brings into, certainly concerns for the court. But the reality is we're here for a pretrial. All right. That's what we're here for, a pretrial. I'm not here for a trial. This is the first time I'm meeting Mr. Wasfrey on this file. First time I'm meeting Mr. Hooks. First time I'm meeting Mr. Robertson on this file. Like, this is the first time that I'm hearing any of the different positions of the parties. Never in a pretrial that I've had, unless the parties have agreed to it, have I just, on my own, just decided, all right, I think the plaintiff's right and the defendant's wrong. I can't do that. I can't do that at a pretrial. Now, the challenge is there are a number of things that the plaintiff is asking for that are certainly reasonable. All right. But the other part for me is if there has been money given to Mr. Javins has been, again, I don't know, and I would prefer, I guess, to have Mr. Javins here to find out what's been going on. But I agree with you, counsel, in to one respect. We're going to bump this over 1 week, and we're going to conduct this pretrial in person. All right, Mr. Robertson, I want you in person. You got to be here, and I know you know where the courthouse is at, because I think you're at the library right now. So you had to be near the courthouse. So you want you in the courthouse. I want Mr. Javins here.
Yes, sir.
Robertson. So make sure he knows about this date. Okay.
Yes, sir.
And then we're going to have to sit down and figure out, I cannot give you an escrow order today, Mr. Rossford, but it will be a topic of discussion a week from today. Mr. Robertson, I want some verification that you have made a payment to Mr. Javins. If I don't get that verification, then I am more inclined to issue an escrow order, whether it's in the amount of $1,800. That remains to be seen, but I can almost guarantee you that there will be an escrow order if I don't feel that any sort of payment has been made in any way, shape, or form on this property by you.
Yes,
so,
sir.
All right. So 1 week from today. All right. So January 15th at 1:30 p.m. in person. I expect everybody to be here.
Thank you, Judge.
All right. I'll let that play. I pretty much let that play out. There's still about 30 seconds left, but it's over. And that is all I have for the evening. Yeah, thank you guys so much for hanging out tonight. Thank you, Biggin, for the raid. I appreciate it. Thank you guys for the super chats, the super stickers, membership milestones. You guys are awesome. All right. Who do you guys want to raid? Lone Wolf or Law Talk with Mike? I've only ever raided Law Talk with Mike 2 or 3 times, but to be fair, he doesn't need the help. He doesn't. He's probably already have 1,000 people over there. So I think I'm gonna go ahead and raid Lone Wolf, just because, yeah. But should I just raid Mike? Yeah, I never raid Mike. I should probably just raid Mike. Let's see. He just started too, so he's not quitting anytime soon. We'll raid Mike. I'm gonna go say hi to Mike, and then I'm gonna jump over to Lone Wolf though. So that's what I'm doing. I just gave you guys my plan. But we're raiding Mike. And then I'm just gonna move over and hang out with Lone Wolf, and then I'll just catch Mike's stream later. Not gonna lie, I can't keep up with Mike's chat. I can't keep up with it. So I go there and I just watch the videos. So I can watch it later. No, that's no insult on Mike. He's just too big for me. It's too big. Can't keep up. All right. Yeah, that's all I got. You guys are awesome. I'll see you tomorrow. That's it. That's all I got. You guys are awesome. I'm repeating myself. Now it's time to go. All right. Until next time. Bye.
Thank
all right. And that's it. And I don't want to get into any, Mr. Robertson, all of these arguments that you have, I'm not making.
I didn't say anything, Your Honor. That was him. I just want to confirm the time. I didn't say a word.
1:30 p.m.
1 week away from here. I'll have my receipts and Mr. Jarvis physically here.
There we
Thank
go.
you, and I apologize.
See everybody a week from today. Thank you.
Yes, sir.
Thank you.
Okay.